Thank you very much. It's a great pleasure to be here today and to follow the session online and to directly follow, as it happens to be, the presentations of Sven and Florence, two people I've had the privilege of working with closely on the presentation that I'm going to give today, the subject of that presentation, the model law for DAOs. So I'm going to be speaking about something that complements their idea for this Hague Convention conference, Hague Conference Convention, on the recognition of DAOs by talking about something that they alluded to, the Koala DAO model law. So the outline of my presentation will be that I'll first discuss some of the pain points that unregistered DAOs, what they call maverick DAOs, encounter. And then I'll talk a little bit about why a model law approach is necessary before turning to the substance of the Koala DAO model law, discussing a bit about the inspiration for the model law, some of which has been referred to a little bit by Sven and Florence, and then going into the principles and implementation, and then a chapter-by-chapter overview of main provisions before concluding by next steps and feedback, where I think it would be really wonderful to receive some responses from the audience that is here today. So if we look at the pain points that DAOs that are unregistered, maverick DAOs as some call them, face, is that the issue that Sven mentioned, legal personality for interfacing with the off-chain legal system, the right to sue and be sued, the right to enter into contracts and so on, is one that is pervasive, and a lot of DAOs are facing this in different ways. And they've had to, in some cases, not only, incorporate and wrap themselves in a particular entity, but in some cases have had to create corporate vehicles of different sorts to be able to achieve these objectives. But in short, there is this issue of legal personality and not having legal personality. The other related to that, of course, is this issue of limited liability and this exposure to unlimited liability for those who are members of these DAOs or participants in these DAOs. Now, many have written and expressed concerns about the possibility of joint and several liability of DAOs if DAOs happen to be classified as general partnerships. This is not conclusive yet because we don't know if courts will construe a DAO to be a general partnership, but that is still something that is a concern. And relatedly, of course, there is the question of whether, what DAOs are, and the fact that there is an issue about the certainty and predictability of their status, and the fact that something like a model law for unregistered DAOs would be able to contribute to the certainty and predictability of this status. Now, many of you might be wondering, based on even previous presentations during this conference, that why don't they just register or incorporate into a flexible LLC form or something? And one of the questions that we've been asking ourselves as well is that in light of this, growth of new types of entities in Wyoming to the Marshall Islands, is what is the unique contribution of this model law? And that is that we believe that it is able to capture the interests of the community of being recognized as a DAO and not losing this qualification by being wrapped into a particular entity. Then there's also the issue that those who have used one of these bespoke blockchain-based limited liability company forms in different jurisdictions have, from our research in the blockchain governance project that I'm part of, have shown that the bureaucracy that is required to use these forms is sometimes very difficult because often there are not that many within a particular jurisdiction, and the local state apparatus that has to deal with these new entity forms have often struggled to do so in a practical level, just in terms of filing documents and dealing with this paperwork. And then so relatedly, this has led to the fact that at the moment, there is no LLC model that provides sufficient lightweight overheads to be able to use this entity while still maintaining the dynamism and flexibility of and autonomy of what a DAO aspires to be. So then the question arises that, if we are going to address these pain points, could we do it by using an international legal instrument that would be able to address these pain points while being accepted in a wide variety of jurisdictions, taking into account that the differences in legal tradition and legal history from common law to civil law to the different legal trajectories that have been taken even in these different families of legal systems. So we thought that drawing inspiration from the existence of model laws, that this could be one potential approach. So model laws are beneficial because they can have a normative function by establishing certain principles that will be applicable across jurisdictions that adopt the model law and establish a certain uniformity of approach. Even though, of course, model laws allow a bit of variation in how they're implemented, this still allows a greater degree of uniformity than what we are currently observing. So in this case, it would be something about building norms around equal, as we've seen in the past with other examples of this within Europe or in other jurisdictions, that having these model laws or this sort of supranational effort creates a push towards recognizing certain norms like equal rights for shareholders, minority shareholder protections, encouraging informal entrepreneurs to incorporate. We see this, for instance, with the Organization of American States Model Act for the Simplified Stock Corporation. And so alongside this normative function, there's also a prescriptive function that model laws can have. They can provide a complete text of a law that can be directly or more or less directly implemented through national legislation. And for instance, it can provide formalities that need to be completed for registration, requirements to be legal representatives, disclosure requirements, and so on, with respect to traditional corporate forms. So this was what we looked at with respect to the fact that they have these normative and prescriptive functions, and to what extent can we draw lessons from this in developing a model law for DAOs. And so, as I mentioned already, this was a joint effort by several lawyers from many different jurisdictions, as well as software developers who are deeply engaged in this space for many years. And the first version of this was released last year in 2021, and I'm happy to share that there has been quite a bit of interest in this model law project. And at the end, I would like to talk about what the next steps are with this. So what were some of the instruments that were an inspiration for this model law? One of them was this OAS Act that I mentioned, because it allows for a flexible governance structure and the fact that an entity doesn't need a board and so on, a real flexibility, both in terms of how to create it and run it, but also the fact that this is being implemented across several different jurisdictions, and that it's possible to use that to incorporate it in several different jurisdictions as an inspiration. So it's not that you have one simplified corporation and it's recognized in several states, but rather that model act can be implemented in different jurisdictions, and then by being implemented, those jurisdictions can have similar simplified stock corporation structures. The other one that was already mentioned, so I won't go into, is this Hague Convention on the Law Applicable to Trusts that Sven and Florence already mentioned. We were particularly interested in Article 11 that talks about recognition, and by states that don't have their own domestic trust law. So that was also really important for us to look at how would states that don't have a way of looking and registering a DAO, how would they approach unregistered DAOs? And so we drew inspiration from the Trust Convention in that respect. And then another one that was very important for us was the UNCITRAL model law for electronic commerce, as that explicitly mentions the idea of a functional equivalent approach in paragraph 16. And here, the idea of a functional equivalent approach is talking about this difference between, if you have a wet signature versus an electronic signature and giving them equal legal effect. And that was also a point that was really important for us in our deliberations. Alongside that, we had to consider some other key questions. We had to consider whether we wanted to draft model provisions or just show some key objectives and principles that should be reflected in a state's law. For instance, rather than a model law, go towards a type of legislative guide. For instance, Untitral has developed this with respect to insolvency law. And then there were questions about how to strike a balance between mandatory rules and default rules, as well as including whether to include substantive prescriptive rules or more towards disclosure rules. And so there were a lot of factors that went into the design and the setup of this particular model law that I can't go into much more detail at the moment, given the constraints of time. But I will go directly into some of the principles and implementation that we envision for this model law. So I've already mentioned functional equivalence being an important principle. Another was regulatory equivalence. Regulatory equivalence relies on the same technique as functional equivalence, but identifies the object or purpose of any given regulation as a goal. It allows for the establishment of equivalence between the function of a legal rule and the function of a technology. So as one example, regulatory equivalence between registration requirements for corporate entities and the deployment of a DAO on a permissionless blockchain. The deployment of a smart contract on a blockchain with relevant data about a DAO is not functionally equivalent to registration in a corporate registry, but the policy objectives of publicity and certainty are being achieved through this disclosure mechanism. And so the model law applies a principle-based approach to identifying the policy objectives and principles underlying provisions of corporate law in major jurisdictions. And the model law seeks to implement these objectives and principles by limiting its scope to DAOs that meet specific technical and governance standards, and by providing rules that recognize that these DAOs' technological features offer satisfactory protections and meet purposes in a manner that's equivalent to the existing law. And so it provides a minimal level of rights, duties, and protections, such as that would address, for instance, the vertical agency problem, as well as, for instance, a horizontal agency problem between majority and minority principles, as well as firm stakeholder agency problems. So those were the sort of three agency problems that also drove our thinking in terms of crafting these provisions. And our goal is to achieve many of the traditional objectives of corporate law to address and mitigate some of the costs that emerge from these problems by relying on technological means wherever possible. So turning to Chapter 1, Chapter 1 suggests that a DAO is a legal entity and that it can be used for both nonprofit and for-profit entities so long as those activities are legal. And then Article 2 bestows legal personality to DAOs that fall within the scope of the model law and suggests that DAOs' liabilities are met by all of their assets. And then the third article provides important definitions. And we see that the Chapter 1 sets out a range of these economic activities, and these definitions are, for instance, ones about what a DAO is. And so we have a more elaborate definition of what a DAO is that refers to the fact that it has to be on a public permissionless blockchain, that it has to have this sort of decentralized governance system, as Sven and Florence had also mentioned. But one thing we particularly allude to is that these governance rules have to be technically decentralized, even if they're not operationally. And this is to accommodate the fact that a lot of DAOs have different forms of governance that we see. They're not all direct democracies or even representative democracies. And as a consequence, we don't want to exclude those DAOs merely because of the fact that they have a different type of governance model at the social layer, even though they might be technically decentralized at the protocol layer or at a technical level. So then, in terms of the formation requirements, this is one of the most important features of the model law, because here we go beyond talking about registration to only requiring these formation requirement criteria to be met for unregistered DAO to be recognized within a given jurisdiction. And so, Chapter 2 sets out what these criteria are. These are both technical requirements and governance requirements that need to be met to benefit from legal personality and for members to receive the protection of limited liability. So one is, as the definition requires, that it has to be deployed on a permissionless blockchain. There has to be a unique public address provided. The software code has to be posted in a public forum so that it can be vouched for independently and audited independently, as well as having a quality assurance audit that is also, shared publicly, so that we have this public disclosure and public possibility of, seeing whether this DAO is actually not only decentralized but also it's robust as as a technosocial system. And then it has to have at least one GUI to read its key variables by anyone who might not have an in-depth technical knowledge of how the DAO operates. In addition to being technically decentralized, it should also have comprehensible bylaws. Not all DAOs end up developing bylaws. Often they do this much later. So this is something that we encourage that they do early on, and that there should be a point of contact for the DAO. Again, this relates to how corporate entities often have to have a point of contact, even if it's just a registered office. And this doesn't have to be a physical contact point, of course, but it can be online. And there should be an internal dispute resolution mechanism. If all of these conditions are met together, then we argue that registration, in the sense that they have to register in when using the Wyoming or other Vermont or other LLC models, that registration requirement would not be needed. Relatedly, Article 5 talks about the limited liability requirement. And here, this is also a very important counterpart to the legal personality aspect. Here, the members will not be held liable for any obligations incurred by the DAO beyond their contributions. Now, we understand that there can be concerns regarding the abuse of limited liability. This may be addressed by DAOs by introducing a requirement for members to make a financial contribution to a reserve fund or towards the premiums of an appropriate insurance policy for the benefit of a limited liability, but we don't make this mandatory. We have our explanatory section where we talk about different options that can be used, but this is something to take into account. And the only time where we talk about a type of veil piercing where we want to sort of mitigate the risk of abuse by members of the limited liability is in the case that we mentioned in 5.3, where members vote against compliance with an enforceable judgment. And there we provide a particular mechanism for them to have to personally contribute with respect to any damages or compensation that might arise from non-compliance with that judgment. So then Chapter 4, to go through this fairly quickly, Chapter 4, Article 6 to 15 seeks to allow DAOs to have as much flexibility in how they internally organize, while not requiring that they have to go into great detail about how this is organized. It builds on the question of how a DAO under the model law is to be governed. And of course, it allows, just as I said, with respect to the OAS's simplified stock corporation, it tries to address the issue of governance by allowing maximum flexibility. Then Article 613 suggests that DAOs do not need to have administrators or directors and so on, making it a default rule rather than something that is mandatory. If they want to have an administrator, they can have one. Article 14 gives a procedure for appointing a legal representative and then explaining how this legal representative is appointed, while clarifying in Article 15 that none of these positions should imply fiduciary status. And we have seen some precedent for this in the US with respect to how LLCs are able to exculpate or carve out certain types of fiduciary duties for those who have these sorts of administrative roles. And we also can look at this recent ongoing tulip trading case to also see that fiduciary liability might not always be as clear-cut as we would think. Articles 16 and 17 provide that by default, the legal representation of the DAO of after a hard fork and how this should be dealt with, because they recognize that, we recognize that in Chapter 5, that DAOs have particular challenges that a corporation doesn't have. And this is because of the technical features they have. One of them is about what to do after a hard fork. And the other one is about what would happen if there is an upgrade. And we provide provisions on how to deal with this. Article 18 deals with failure events. So if there is a technical failure, we argue that there should be a continuation of legal personality and limited liability, unless there is some form of manifest bad faith or gross negligence that is happening. And while Article 19 deals with what to do if the bylaws of the model of the DAO isn't able to encompass all of the different sorts of issues that might arise. And we argue that whichever jurisdiction is adopting the model law, their general business organization law should only be used to fill this lacuna. And then finally, Article 20 provides that DAOs should be a pass-through entity for tax purposes. And what we are trying to do by this is to invite DAOs to opt in to be integrated into the legal system, even while being unregistered. And I present to you here 3 questions that I hope those who are here or those who will be watching this video later might consider. And that is about what the content of the articles should be, as well as whether the model law is the right type of instrument or we should look for another option. Thank you very much for your time.